Thank you. Good morning, everyone. Can you hear me? Yeah. Okay. It is truly my honor to introduce my friend, and I'm so sorry that she's gone from Tulane, my friend, Professor Amy Gajda. Many of you know that she is the current Jeffrey Forcelli Professor of Law at the Brooklyn School of Law. They stole her away from us. She was previously a law professor at Tulane, former class of 1937 Professor of Law. But for purposes of this discussion, what is so important is Amy is also a former journalist. So she's bringing that perspective and addressing these issues related to defamation, freedom of speech, right to privacy, etc. She is one of the foremost experts on privacy and media law, and she is the author of this phenomenal book, Seek and Hide, The Tangled History of the Right to Privacy. And I'm excited to say that this book was recognized by the editorial board of the New York Times in 2022 as one of the top 100 books of that year. So please give another round of applause to Amy.
Thanks, you all. Thanks so much.
Guys, we're going to jump right into it because I'm so excited to be able to speak with Amy about this. I'm not an expert, but this is one of my passions, particularly with everything we see going on in the country right now. So Amy, let's start with kind of a basic question. Actually, what is the so-called right to privacy? How would you describe that?
So I think that that's a really wonderful question. And I will say that there's no sort of one nugget. There's no one definition that fits privacy completely. What I write about and think about mostly is the right to information privacy. So informational privacy, how much can be revealed, for example, about someone before too much has been revealed and the speaker or the publisher might be liable for publishing that truth. I think that's fascinating because we know, I think through college, we learn about defamation and how defamation is harms one's reputation because it's false information. I think it's incredibly fascinating that one can sue for the publication of truth, and the publisher can in fact be liable for that. But in addition to that sort of privacy, of course, we all know that that there's decisional privacy, and that was decided by the court in the Dobbs case, and also in addition to informational privacy, the informational privacy that I mostly like to think about. There's also, of course, data privacy. There's something that is huge right now in athletics, and that's the right to name, image, and likeness. That's actually a privacy concept too. Intrusion is a privacy concept, and that means hidden cameras recording us, ring doorbells maybe. And then there's also something called false light, which is very similar to defamation, but it's under the privacy umbrella. And what's really interesting today is that courts are embracing that idea more and pushing back on publishers' rights more generally. So it's a really interesting time. There's no like one perfect definition for it. And I remember writing the book, and I remember my my editor saying to me, like, you know, you've never really defined it. What is it? And so I sort of hope, like, you know, you might read the book and get this sense of things in a very broad way, because really privacy is what courts and legislatures decide that it is.
Well, actually, Amy, you did kind of define it in your introduction. I wrote down that you said that people generally have the right to keep certain things quiet, to define themselves for themselves against the interests of others. So you kind of gave a definition, but I want to jump to what you just said. You referenced the Dobbs decision, and I think everyone in this room is aware of what the Dobbs decision is. Overruled Roe v. Wade relating to a woman's right to choose concerning abortion. And I want you to reconcile the issues addressed with privacy and Dobbs with one of another statement that you made in the introduction to your book. You said, through it all, it's pretty clear that privacy will ultimately win out. And as good as that may sound right now, it's not always the best thing. So how do you reconcile how the Supreme Court dealt with privacy issues in Dobbs concerning a woman's right to choose with this statement that privacy will ultimately win out, because many women don't believe that privacy will win out after the Supreme Court's ruling in Dobbs.
Right, and I should say the book was published like just a few months before the Dobbs decision came down.
Yes.
So I was thinking about that, that possibility. But the reason why I stick with this idea that that privacy is going to ultimately win out is the way I think about privacy, which is in an informational privacy sense. And so what the Dobbs court did is the Dobbs court decided that this right to decisional privacy, right? How much we can keep the government out of our lives. And I should say this, in a constitutional sense, right? So in a constitutional sense, do we have the right to abortion? Dobbs says no. And Dobbs says because it's not rich in the nation's history. And what the Dobbs decision does, though, is it suggests that there's a very different type of privacy out there, and that's informational privacy. And so the Dobbs decision itself suggests that we look to history to try to figure out whether or not there's a constitutional right to that particular type of thing, and it delineates between that decisional privacy and that right to privacy and information. So because of that, and because just a few months before they decided the Dobbs case, the court wrote that there was, in effect, I'm not quoting here, there is privacy in little things, including a person's home address. And the court suggested as much, and then it threw in a footnote, and the court suggested as much because of doxing. And so the court is very aware of the concerns about doxing and that sort of release of truthful information, including a person's home address. And that's why I suspect that think about abortion in an informational privacy sense, which becomes critically important in some jurisdictions where the telling, where there's statutes that suggest that you have to reveal this sort of information. I think that even this Supreme Court, if that sort of case went up to this Supreme Court, in other words, if a publisher published, and by publisher I mean someone on Facebook or someone in a newspaper or whatever, if someone published that a woman had had an abortion, I believe that even this Supreme Court would protect that woman's right to privacy in information. And I know that just probably blows your mind,
yes.
And yet there is a rich history of precisely that. So the court says throughout its history, the courts, and I guess there are two important things about history here. Number one, the court suggests in early cases, and by early cases I mean the 70s and 80s and 90s, that the information privacy is in fact a constitutional right. It springs from the First Amendment and other places, but they literally suggest that there is a constitutional right in information privacy. And the only question is, at what point does the right to speak or the right to publish then quash that right to information privacy or vice versa? That's all the court's written. But then we look at Dobbs, and Dobbs suggests that what we need to do is go back in history to try to figure out what is protected constitutionally. And if you go back in history, even before the First Amendment was ratified, the founders talked about the right to privacy and information. They wanted to specifically protect, I wish I could remember the phrase. Because it's such a delightful phrase. I can't remember it right now. But they wanted to protect a politician's extramarital affairs.
Oh, I'm sure they did.
And so literally you have John Adams writing to a man who would later, William Cushing, a man who would later become one of the very first justices on the United States Supreme Court. And they literally said, I remember the phrase. Cushing writes to Adams and says, hey, we have this new thing that's called the first, might be the First Amendment. I'm a little bit worried about this because when we say freedom of the press or freedom of speech, do we really mean like blanket freedom of press, freedom of the speech, or are there some sort of limitations on that? And Cushing writes to Adams and says, what about a politician's instances of male conduct?
Male conduct, though.
Yes,
male
exactly.
Conduct.
So what about this? What about these instances of male conduct? Shouldn't this be protected on information privacy despite the First Amendment? And John Adams responds, of course they would be. So yeah, we have this thing called freedom of the press and freedom of speech, but we don't mean freedom, of everything. There are certain things that are off limits, including instances of male conduct.
But wait, Amy, let me push back about that a little bit.
Sure.
Because even in your book, and I'm only going by me seeing the play Hamilton, but even in your book, I can only do that, guys. But even in your book, you talk about how the press operated back then, and you talk about the fact that these guys really attacked each other. So Hamilton is being attacked based upon the fact that he had an extramarital affair with Mary Reynolds, whatever her name was. He's attacking Thomas Jefferson because of his completely inappropriate and illegal relationship with Sally Hemings. So how does all that tie in when we're talking about the Founding Fathers and what's going to ultimately end up in the First Amendment and how it's interpreted? Right.
So at that point, then the First Amendment is ratified, right? Okay. So there's that discussion, and then the First Amendment is ratified. And then Hamilton agrees to represent an editor.
Right.
And this was an editor who'd reported, in part, the Sally Hemings story, so hinted very broadly, her name is Sally. And so Alexander Hamilton agrees to represent that publisher. So, he represents the publisher. He represents the newspaper editor. And what he argues is that there are certain things that are off limits, of course, that if someone reveals a person's family life, information about their family life, in a way that would harm the family, this is off limits. No freedom of the press, no freedom of speech for that. That's what he argues representing the publisher. And needless to say, the publisher went to jail and also had to pay a fine. Move ahead to 1803, there's this really interesting case called the Croswell case. And in it, what had happened was the government had put a newspaper editor in jail, and Thomas Jefferson then celebrated this fact. And so when we think about Thomas Jefferson, at least I remember, before I became a lawyer, I mean, I used to have I think even on my desk as a journalist, I had this saying. I can't remember what Jefferson said. You all might remember, but it was something like, if I could choose food or freedom of the press, I would choose press freedom. Something like that. And that is so utterly wrong, because in 1803 he was like, bring me that editor. Let's take him down.
He was known to be hypocritical, Amy.
For
so
sure. Yeah,
we'll
for sure.
Yeah,
no, you're exactly right. Of course. Yeah. So anyway, a very interesting history of this sort of privacy. And what makes it so critically important, of course, is because if we look to Dobbs says that we get constitutional rights from history. And there you go. Pre-First Amendment, we had this discussion, or not we, but the founders had this discussion about the things that would be off limits, including these instances of male conduct.
But I want to jump to, we'll get back to privacy, particularly when we start getting questions from the audience, but one of the other things that you tackle in the book relates to defamation. And we're reading a lot about defamation claims, and what's interesting now to me is that you have a lot of public figures, people that have run for office, so they completely fall under the umbrella of being a public figure. And to me, if you're a politician, you got to be able to take it. You have a lot of politicians saying, I've been defamed, and you have this pushback against the Supreme Court's ruling in 1964 in New York Times versus Sullivan as it relates to the high threshold for holding, for a public figure to make a defamation claim. So where are we now with that right now, Amy?
So what's really interesting is that, so I've been studying media law and privacy law for 25 years, so for a very long time. And one of the things that's been so intriguing for me as a former journalist and also as someone who's looked at it for so long is how courts today, it used to be that if you were a public figure or a public official, you'd basically not win your case ever. It didn't make sense to bring a case because of actual malice. And what actual malice means is knowing falsity or with reckless disregard as to falsity. And basically that suggests that if a publisher publishes something that's reputation harming, as long as they didn't know it was false, or as long as they didn't act recklessly in publishing that information, they were protected. So actual malice was this incredibly difficult standard, so difficult for these public officials and public figures to meet, which is why Donald Trump and a lot of other people oppose New York Times versus Sullivan, want to get rid of actual malice. Anyway, here's just one example of a case that was decided a few years ago now. My students in the room will know this case. I hope they'll remember it. Sarah Palin was defamed, she argued, by the New York Times.
She argued.
Right. By the New York Times editorial board publishing this image. Anyway, I mean, the bottom line was she argued that she'd been defamed. The trial court in New York, the federal trial court, decided she didn't have a claim and threw the case out, right? No actual malice proved. No way you can prove actual malice here. The federal appellate court for New York, the Second Circuit, a hugely media-friendly court, incredibly media-friendly. So many of these media cases that support and protect media were decided by the Second Circuit. The Second Circuit decides she has a valid claim. The Second Circuit says actual malice can be proved in this case. And then it gave 4 reasons why actual malice could be proved. And so it sent it back to the trial court for trial. So that, to me, was this wake-up call. If the Second Circuit, a media-friendly court, is deciding this sort of case in this way, when it would have been so easy for the Second Circuit just to uphold the lower court's decision, that didn't happen. The Second Circuit said, no, actual malice can be proved here. A jury needs to decide, but we think that a reasonable jury could decide that it was reckless disregard, or reckless to publish this information for these 4 reasons. So it literally lays out for other plaintiffs in future cases how they might prove or they might prove actual malice exists.
Was the Second Circuit looking at a subjective standard or an objective standard for actual malice? Because I am trying to figure out,
sure,
as a lawyer and as a person who reads the newspaper,
sure,
how you can ever defame Sarah Palin in the first place.
No, it is.
Start from that standpoint, but what do you need to prove for actual malice to defame the likes of Sarah Palin?
No, it's a really interesting, that's a really great question, of course. And so what they suggested was that the information that the New York Times had published suggested that Sarah Palin, through her PAC, had linked or had put bullseyes. Thank you, bullseyes on certain targets of politicians in the United States, including Gabby Giffords. And so, in other words, the suggestion was that Sarah Palin had in fact caused, in effect, Gabby Giffords being shot. That's why she sued.
Was it satirical?
No, it was very serious.
Actual
it was
news article.
Yes, it was.
Okay.
It was an image, and so a graphic. And what happened was the court said, here's an editor who took a look at this, this image and okayed it, and that editor knew through previous articles that he had edited for The Atlantic that this was not accurate.
Okay.
That in fact, the person who shot Gabby Giffords had not
Right.
been then been associated at all with that sort of incitement. And so it was that, which is deeply troubling as a journalist, because I cover so many stories. I can't even tell you. If you forced me right now to give me 10 stories that I covered in my work, I probably would not be able to do that. And so that's why I'm really worried about it for journalists, because if we cover stuff and then we're supposed to remember everything, that's a really difficult actual malice standard.
But didn't the jury ultimately rule against her?
So what happened was, and I haven't looked at it since, but what happened was it was sent back to the trial court, and what the jury decided that actual malice had not been, what happened was the jury goes into the jury room, and the judge then apparently, and I apologize to Judge Rakoff if in fact I'm describing this incorrectly, the judge then gathered some members of the media together and said, no matter what the jury decides, I'm going to find that actual malice doesn't exist in this case. So I'm going to find that actual malice doesn't exist. Of course, when the journalists heard that, they then tweeted that out. And the jurors in the juror room got that information. And so that then because the plaintiff, Sarah Palin, argues that decision was tainted by the tweets, it went up then to the Second Circuit. And I know it's been argued that the Second Circuit, I don't know what the Second Circuit has decided in that case.
But that is a taint. That actually is a taint on the jury verdict.
Yeah.
And just as kind of a postscript to what Amy's talking about, I was just reading yesterday in Florida, like right now, their legislature is considering this whole line of statutes that totally removes the standard for actual malice for public figures. And you know how progressive and wonderful a state Florida is when it comes to issues of this nature. And actually conservative writers and conservative lawyers are pushing back, saying you're opening the doors way too much, because at the end of the day, these are public figures, and you don't want this low a threshold, because it can come back against me as a conservative radio announcer, me as a conservative owner of a television station. So there actually is a lot of pushback from the conservative side of the media and the law as it relates to the statutes that Florida actually is considering right now. Now I want to ask you, Amy, about this issue of the right to be forgotten, particularly when you're talking about someone who actually has a documented public criminal history. So because it's criminal, it's public, it's wherever it is, how does that tie in, and is that tie-in proper?
Yeah, that's something very interesting that's happening in the United States right now. So we might think about the right to be forgotten as being this very European concept, but actually in recent years, within the past 5 years or so, there's been a real embrace of a right to be forgotten in the United States, both legislatively and then also newspapers as well. So let me talk first about legislation and really court decisions. What some courts have decided is that if someone publishes a website, for example, that reveals another person's criminal history from 10 years before. So in other words, this revelation of information that's absolutely true and on some public record, but is deeply humiliating for the individual, courts have suggested that they can win a privacy claim, meaning that the person it's really interesting, isn't it?
Judge Foote. Judge Foote is.
Yeah. No, it's incredibly fascinating, and actually, I'll say that this is, for the lawyers in the room, this is actually a part of the Second Restatement. So the Second Restatement from 1977, literally, this is a critically important legal treatise of sorts, very influential in the law. It says that if Jean Valjean's criminal history was revealed by Javert and a newspaper, that Jean Valjean from Les Miserables, because he had turned his life around and because it was 10 years before, that he would have a right to privacy in that criminal information. So in other words, there too, there's a really rich history for this sort of thing. And the other thing that's really interesting about this, I think, is that the way we define privacy, can't really define it, but the way we define it in part is what society does. So what are our cultural norms? And what's really interesting now is that journalists are removing criminal histories from their news stories. They're getting rid of mugshots and they're getting rid of old criminal stories. All you have to do is ask. And so my belief is within the next 5 years, and there's a rich history for this, within the next 5 years, this is going to be the norm. We're not going to have mugshots anymore. We don't have them much in Louisiana anymore because of a statute that was passed in Louisiana. Other states are passing the same sort of statutes, restricting access to that sort of information that was once so easily gotten. I mean, when I was a journalist, all we had to do was call up, we'd get the person's picture and we'd put it on, I was a TV news anchor and reporter, we'd put it on the TV. Well, that's because we only chose people who were newsworthy in our opinions.
Right.
We put up pictures of bank robbers and such things. What's happened now, of course, is that you have websites that literally publish hundreds and hundreds of people every day who've been arrested for things like public urination. And that image is out there forever. And because of that now, legislation is restricting access to that sort of thing. So really fascinating stuff.
But,
again, when we think about the First Amendment, I think we think about freedom to publish truth, and it just does not exist. But
let me follow up on
sure.
that, Amy, because I really wrestled after I read your book with, I'm going back to the right to privacy, is there a real private interest now in light of where we are with social media, with social influencers? I mean, I'm not on social media at all. I don't have time for all that. It's a whole nother world of me.
I'm going to like that.
Right. Yeah, right, like it.
I'm just kidding. I'm not on social media either. So.
People publish, I fixed gumbo last night. I went to dinner with my friends. Yeah. This is me with my date. This is me doing other things with my date. People put everything going on in their life out there, just out there. So what's private now? So what's private that the courts are actually trying to protect as it relates to this right to be forgotten?
Sure. So two interesting things. Number one, some courts have decided that if you post something on social media and you intend the reach to be very limited, so in other words, you intend to reach only your friends, and you're revealing something deeply private about yourself. I have cancer, everyone. I just want to let you know that. What courts have suggested is that even though that's available online, if I only intend to reach my friends, I can still have privacy in that information. So it's courts are coming around to the way we communicate today, I think. The second thing that I really am excited about and am looking for, and I'm actually writing a book on it right now, is what's happening today, even today, but maybe especially a couple years ago or so, with parents publishing deeply humiliating and embarrassing things about their kids, or other adults publishing very embarrassing and deeply private information about their kids. And so that then is something we have to watch out for in the future. These kids are going to be harmed by that information, and they're going to sue. Someday. They're going to sue for the revelation of that information and how it harms them, maybe in employment, maybe in their love life. Who knows how that information is going to be used. And so, watch for that too. Think about the right to be forgotten and that sort of thing too. Once it's out there, can it become private again? Courts would say yes.
Well, I want to ask you, Amy, and we have several judges in the room, but bottom line is, how are we balancing the public's right to know? Because there are certain things, I think everyone in this room will agree, that the public probably does have a right to know as it relates to government officials or corruption going on in government, things that directly impact us either from a public fist standpoint, etc. How are we balancing the public's right to know with where the courts and to some extent Congress is moving as it relates to more restrictions or exceptions to FOIA, the Freedom of Information Act, and as it relates to allowing plaintiffs in certain instances to file lawsuits anonymously. Most of us think that if you're going to be big, bold, and bad enough to file a lawsuit, you probably should use your name. And as it relates, because this is going to come up in the, 800 Trump cases? However many cases are out there. 800 Trump cases are out there. Should the jurors be anonymous in every single one of those cases, or should it be maybe just in the criminal context, whatever?
Yeah, it's a really wonderful, really wonderful question. I mean, again, so many of these courts deciding these cases suggest that the internet has changed everything. And so if someone's in the courtroom and they're hearing the revelation of information about someone, so when you're a juror, for example, in some states, they will literally ask you, what is your criminal history? What's your family's criminal history? They'll ask you other things about your, whether you've ever been sexually assaulted, depending on the appropriate case. And so judges are recognizing this and recognizing the information might get out there. And so they're allowing plaintiffs to sue without revealing their names, just going with initials sometimes, and other very interesting ways to cloak this sort of thing in privacy. I'll tell you, I was just talking with a judge about this, and I then literally read, I don't know if you've all been following the Detroit father,
yes,
whose son shot up a school. So he was just convicted a few days ago. There was a graphic description of each juror, even though the jurors weren't named. There was a graphic description of who each juror was, including things like, suggested what their employment was, suggesting their history, anybody who but in addition, for me, thinking about these issues, also their kids.
Oh, wow.
And their kids' mental health histories.
Oh, my goodness.
For the jurors who are being chosen for this case. And, think about those kids. Think about those kids. When I'm going to know, if I'm in that community, I'm going to know who a juror is in that case. That case is national news. I'm going to know those jurors. The media literally talked about the kids, the jurors' kids' mental health histories. I mean, just shocking for me as a journalist.
Now you're talking about what's called the mainstream media, or are you talking about what's called kind of the fringe media?
No, sadly.
Well, why would a responsible journalist, since you are a former journalist, you've commented on these issues, why actually would a journalist do that? And don't you guys have certain standards that, you're supposed to follow from an ethical standpoint? Why would you do that?
So we do. So, and among those things is privacy. And so there's the suggestion that we need to balance privacy with newsworthiness. And my guess is that the journalist and maybe the editorial board said it's crucial that some of these jurors have children who have mental health histories, that's an important part of the story here, and that therefore we're going to reveal it. That's my best guess. If I can tell you, there were many things I did not report, and that would be one of the things that I would not have reported when I was a journalist. It's so utterly unfair, both to jurors, the juror himself, and I think there was a woman too, who had that revealed about them, and then also those kids who now can be connected, I'm sure, with in some way with that trial, and people will figure out.
People can easily figure out who they are.
Right, and I should say, even though it's not like we don't want to say that a mental health history is so devastating or anything like that. But my point is that we don't know if there's an employer out there who's going to say I'm not going to hire that person. And what does that do to that poor kid?
Or their peers raising questions. But let's talk about something that you focus on at the end of the book, Amy, and this really touched me because this was one of my heroes. At the end of the book, you tell the story, and for those of you who have gray hair like us, you might recall Arthur Ashe, the African-American tennis player, won Wimbledon, first African-American male, to win Wimbledon, the U.S. Open. activists, major civil rights activists, fought against apartheid, but as you know, he had a heart problem. And so during a blood transfusion, he got AIDS. And this is in the early 90s when AIDS was taboo and no one wanted to talk about it, and there was a stigma attached. Before he and his wife, and they had a 6-year-old daughter, made a decision to publicly disclose that he had AIDS, the media forced him to. And you talk about that at the end of the book, and I always thought that was so unfair. Tell us what went into you including this in the book and why, Amy?
Well, because like you, Arthur Ashe was a hero to me. I loved Arthur Ashe. I followed Arthur Ashe, and I, again, being a journalist, I thought that this was just so utterly wrong to reveal that sort of thing. And if you watch his speech, he cannot, revealing that he's HIV positive and more. He breaks down and can't finish his speech. And so his wife then takes over. So again, at least journalistically for me, I would not have reported it. I don't see the news value in that. I would let someone else report it, meaning let him decide. And my point with that is that I think that that's where the law is going now too. Because now suddenly we're not only talking about the New York Times and Washington Post and Wall Street Journal, we're talking about people who are going to reveal this sort of information to harm others. And so now you get courts who used to be all about press freedom, speech freedom, press freedom, because we can trust the media to make those judgment calls about news accurately. And now today everybody's a publisher. And so everybody, thinks if it's true, I'm going to go ahead and publish it for whatever reason to harm people emotionally or otherwise. So that's why now we have this turnabout in the law and this fuller recognition of privacy, which troublingly will protect John Adams and William Cushing and their instances of male conduct. Perhaps I don't think we'll ever get there. I think that sort of information will likely always be protected by the First Amendment. But I do think that medical information, health information, and other things like that then will continue, already are, but will continue to be protected as well.
Amy, before we take questions, because this has been a great discussion, and I need to turn it over, but can you tell the audience very briefly the little postscript that you add at the end about Arthur Ashe and the children's books? I think that just kind of sums it up. So there's a book, and it's Dignity. There's a book that for children that teaches kids important principles. It was a series, and for Dignity they chose Arthur Ashe. And they suggested, how dignified he was to come forward and, suggest what had happened to him and how utterly it was unfair for the media to report what it did. And the reason why I think it's so interesting is because dignity in privacy is very much a European concept. And so in Europe, we look to dignity. But increasingly in the United States, courts are using dignity as well in these privacy sorts of cases, suggesting that a person's dignity is the most important thing and should be protected even above speech and press and First Amendment freedoms. So I think that sort of puts my belief in what's going to happen in the future in a nutshell, that we're moving increasingly toward this. And even as a former journalist, I don't think this is a bad thing. Guys, this has been an absolutely fantastic discussion. Can we give Amy a round of applause before we take questions?
Yeah, thanks, you.
Absolutely phenomenal. And I strongly suggest you buy and read the book. It is fascinating. But does anyone have any questions? And if you do, can you please step up to the mic? Ma'am? Oh. Either or.
So I had a question. You were talking about the lessening of public access to criminal records. Recently, I believe there was a bill in Louisiana talking about making juvenile records public access.
Yeah.
Really?
So I was wondering, like, that sounds kind of like contradictory to what your hopes were. I was wondering, like, what your thoughts were on that. I'm not sure if it was passed or not.
No,
So I would guess it's not going to be passed because, I mean, that's my.
It is.
It
It's gonna
is going to pass?
Absolutely. It is.
Are you kidding me?
No, absolutely.
Oh my goodness, I had such a, sorry, I've moved to New York, so I've not been following. I
All
do
the
read,
criminal-
I should
all the
say I do
criminal
read
justice
NOLA.com every
reforms,
day.
Amy, that came up under
Oh, I
Governor
guess.
John Bell
Oh,
Edwards.
goodness.
are
Okay.
being
Anyway,
flipped.
yeah. Okay. Never mind. Because I actually use Louisiana when I talk about mugshots. I mean, the fact that this state passed that sort of protective law, I was so excited about it, and now I can't believe that they're going to do that. I mean, that's and oh, you know what's going to be really exciting then? That's going to be your Supreme Court case, my friends.
Good. Good.
That's going to be the Supreme Court
Good.
case. It's going to be the state deciding that something that has traditionally been protected on privacy grounds can be revealed. And that's going to be then that right to privacy, right to information privacy that has existed from the very beginning of the United States through to today. The Supreme Court, it could be that sort of case. That's interesting. I'm sad for the kids, though, whose criminal records will be revealed.
I did have another question as well. You referenced Dobbs, and I feel like that Supreme Court decision kind of like showed a shift in like conservative mindset concerning privacy, considering traditionally conservatives tend to be like very like we want small government, we want them as uninvolved as possible. So like, what do you think that shift signifies, and like, do you think it'll spread to other issues?
So I mean, my read of Dobbs, and if you read Dobbs, it literally suggests that there's a difference between that sort of privacy, right, and that abortion privacy and a right to privacy and information. So literally, that court decides it. And as I suggested, just literally a few months before, the court was writing about privacy in home addresses, for heaven's sakes. And so I think the more, and moreover, they suggest that that it's important to look if there's constitutional privacy. That constitutional privacy has to exist in history. And I'm telling you, it does, from the time of the 1600s and then even before the ratification of the First Amendment. So that's what's so deeply interesting about it. I think that it's possible that even this court would. And if you read the judge's writings as well, and I can tell you I know enough about some of the justices that I do know that they very much want privacy in their own lives. And so therefore, I think that that's going to hit at some point too.
Okay, thank you. We have time for a couple more questions, ma'am.
Would you please speak about book banning?
Oh, sure. Yeah.
We have time to get to it. Thank you
Okay,
for
yeah.
asking.
Oh, yeah. Right. Thank you. So book banning. I'm so glad you asked that question. So basically, let me just tell you very briefly. What I want to do is I want to read you a really lovely, not lovely, but a really good description of these sorts of cases, book banning cases. This is what a federal district court wrote this year, so 2024. School officials cannot remove books solely because they disagree with the views expressed in the books, but that they can make content-based removal decisions based on legitimate pedagogical concerns, including things like pornographic or sexual content, vulgar or offensive language, gross factual inaccuracies, and educational unsuitability for certain grade levels. And you might think that sort of balance, right? You're giving then justices and judges and school officials the ability to balance in a way that many of us probably would not agree with. But what's deeply intriguing to me is I looked over the course of the past 2 years, and there have been 10-ish cases involving book bans, and in every single one of them, the people wanting the book bans have failed. So they have not won. And I think, my read of the cases is that a lot of this is political. They want to bring these cases to force the issue. And so that's the good news, is that at least right now, all these cases are really new. They're decided only by the trial courts. Right. They're going up to the intermediate level appellate courts. The Fifth Circuit here just decided one a few weeks ago and decided that in fact the book ban would not stand, at least as the legislature suggested it
I'm
should.
going to ask you who was on that panel after this gentleman asked the last question. Yes, sir.
Thank you. Like you, Amy, I formerly lived in Louisiana. I opened the paper this morning, the Times-Picayune, and I was astonished to see about a half page of mugshots and descriptions of sexual offenses with their home addresses. And one of the things I wondered is who paid for that? Do they have to? Presumably, the offender might be made to pay for that as part of his or her whatever sentence, court decision. But I don't know of any other state that actually does that when people are convicted, to say, I know there's an argument that you wouldn't want to move in next door to a sex offender. I would also think you wouldn't want to move in next door to an arsonist. You wouldn't want to move in next door to somebody who poisons dogs.
Yeah. Yeah, because of the recidivism rate in sexual offenses, that's the reason why previously that sort of information has been.
But the recidivism, the 90% something is widely discredited.
Yeah,
it was one Canadian researcher.
Yeah, and you're right. But I guess my point here is that what I'm deeply intrigued with is how those got published. So was it a part of a news article?
No, it's a whole section in the Times-Picayune. It's treated. It looks like news. It doesn't look like a paid ad.
Oh, I have not seen it. I'm going to buy.
I'm sorry, I left mine on the breakfast table.
Yeah, right.
But,
no, I'd love to see it. I'd love to see it just to try to figure out whether or not this was some sort of, in your face. We need this sort of information to, rile the public or whatever.
That was what struck me as well.
No, it's really interesting. Thanks for bringing that up. Can't wait to look for it.
Yeah,
thank you.
Guys, this was a phenomenal discussion. Amy Gajda,
Thanks,
if you have not bought the book, read and buy the book.
And I adore this woman.